Hi, and welcome to 2 Minutes with Hull and Hull. I'm Ian Hull, and the topic today I want to cover is timing. Now, everybody knows a little bit about lawsuits being time sensitive, and the courts have set out fairly specific parameters on what we call limitation periods, and as do the statutes right across Canada. In Ontario, for example, you have essentially 2 years to commence a lawsuit if you're going to make a claim. Now, there are exceptions because every rule has an exception. And the exception to the rule can be that the time can be expanded based on certain criteria, whether you discovered the lawsuit or whether or not it's within the ultimate, for example, using the Ontario example, the ultimate limitation period of 15 years. So the old saying that a lot of business people use and people are familiar with in the legal community, of course, is time is of the essence. So it is also time is of the essence with estates. While there are numerous examples of exceptions, the hard and fast rules are what I like to make sure my clients understand the basics on. And that is that we typically have 2 years from the date of death to make a claim against an estate. And those limitation periods are also different with regard to the types of claims you're going to make, and they are shortened significantly depending on the nature of the claim. But having said that, the good rule to follow is if someone passes away, you probably have somewhere between 6 months and 2 years to move forward on any claim. In my next podcast, I'll go through some of the specific unique estate rules that tie into limitation periods. But those are the basics. Thanks so much for joining me with 2 Minutes with Hull and Hull.